Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration Law, and this video is a continuation of our series on the H-1B visa classification. In this video, we're talking about the H-1B cap-gap provision. The H-1B cap-gap provision refers to a section of the regulations that allows a student studying on F1 who is working on OPT or STEM OPT to have their work authorization automatically extended until September 30th of that year if they have been registered in the H-1B lottery and selected in the lottery, and if they meet certain other criteria. So what does this mean? The cap portion of cap-gap refers to the H-1B cap, or the annual numerical limitation on the number of new H-1Bs available every year. Our most recent video in this series outlined what the H-1B cap or annual limitation is and what the H-1B lottery system looks like. The gap portion of cap-gap refers to this very common scenario where a student who is on F1 status, foreign national student on F1 status, is working on OPT or STEM OPT. We also have videos in our series earlier on about these two classifications. But a student who's working on OPT or STEM OPT, if that OPT expires before their H-1B status will become effective on October 1st, if they meet certain requirements, they are eligible to keep working without interruption in their work, even though their OPT will have expired. So what does that look like exactly? There are certain requirements that have to be met. First of all, we're talking only about students who are in F1 status and who are working on valid OPT or STEM OPT. Second, the foreign national student has to have been registered in the H-1B lottery, and they have to have been selected in the H-1B lottery. If they are selected in the H-1B lottery, their employer has to timely file an H-1B petition. That means that they have to file between April 1st and June 30th in order to qualify for the cap-gap. In addition, the H-1B petition filed for this person needs to be filed as a change of status. That's a box that we mark on the H-1B petition forms, indicating that we would like for the student status to be changed from F1 student status to H-1B. If the petition is denied, or of course, if the student isn't selected in the H-1B lottery, then this provision no longer applies. In addition, a student cannot have had an F1 status violation. If a student qualifies for H-1B cap-gap, they are, as I said, permitted to work until September 30th of that year. Ideally, their H-1B petition would be approved by that time, and their H-1B status would kick in and become effective on October 1st, meaning they're able to work without interruption, even though their OPT ended, let's say on, for example, on July 3rd. Of 2023. If they meet these requirements, they would be able to continue working. They do have to obtain an updated I-20 from their DSO or designated school official just to indicate that they have this continued work authorization, but otherwise there's nothing that the employer needs to do. One point about cap-gap or about travel in general. We get lots of questions about travel for individuals who are being registered in the H-1B lottery and who would like to travel potentially between the time that they file the H-1B petition, if they're selected, and October 1st, when their H-1B status comes into effect. If a person files for a change of status from F1 to H-1B, or from another classification to H-1B, if you file a change of status, if you leave the United States while that change of status is pending, then the change of status portion of that request will be deemed abandoned and denied. The H-1B petition itself, if it's otherwise approvable, would still be approved, but the change of status portion would be deemed abandoned and denied. However, and so that means if the change of status is denied, then they would no longer qualify for the H-1B cap-gap if they're trying to take advantage of that. However, it is possible to travel once the H-1B petition has been approved. So if you're a student in F1 working on OPT, wanting to take advantage of the cap-gap, it may be still possible for you to travel as long as the H-1B petition has already been approved. If you are in this situation, or if you have an employee in this situation, definitely talk to an immigration attorney to talk through all of the facts and timelines to make sure that the student's or employee's situation case is not negatively impacted. But it is possible to travel in some circumstances. Our next video in this series will be about the H-1B transfer. Until next time, my name is Emily Sumner with Sumner Immigration Law.